Hello, everyone. My name is Nita Den, and I'm going to be presenting the webinar here today. I'm really very excited to be here. And before we actually get started, I just want to let you all know that you see the bar on your left right here. If you want to, you can click that with your mouse and adjust the size of the PowerPoint and my screen. You're able to make my picture bigger so that we can be accessible to everyone. I'm going to give you a minute to adjust your screens. Okay, I also want to let you all know that we do have a voice interpreter today for the webinar. While I'm signing, we do have audio available for those of you who need it. I also want to let you know that I'm very excited to be here today. I am a family lawyer. I am also a divorce attorney. I've been practicing for almost 4 years now. And I've had a lot of experience working with both hearing and deaf clients. And one of the biggest, most important differences that I've noticed between the two groups is that when I am consulting with a hearing family and talking about the divorce process, they are already aware of many of the parts and pieces of this because they've had access, to online information, English and all of that, or they've had family and friends that have discussed their experiences in going through divorce. So when they come to see me, they are very prepared and aware. Occasionally, I might need to clarify something or explain it, but they understand the foundations already. But when I speak to my deaf clients, I've realized that I have to explain so much more because access has been so limited for us. So now I'm really excited to present a webinar that will provide you with all of this access. And this is really for people who live in Texas and they're thinking about the divorce process or they want to know more about it so they can share with their friends and family and people they may want to support. So thank you for being here. I also want to let you know this webinar is going to be recorded. It will then be uploaded to our YouTube channel here at Kimbrough Legal Services. We have several different webinars that have been placed on our YouTube channel, and this is going to be added to that. So please don't feel like you need to take notes or anything like that. I know there's going to be lots of words and terminology and vocabulary for you today. All right, next slide. Okay, so of course, as a lawyer, I have to share some disclaimers. I have to protect myself. So when I'm explaining and sharing information today about all of these different aspects of the divorce process, I don't want anyone to assume that this is legal advice. It is not. I'm just sharing information for educational purposes today. I am not giving any legal advice to you or creating an attorney-client relationship at all. Also, I want to let you all know that I am licensed to practice in Texas only, not in other states. So if you're thinking about filing for divorce in another state, please be aware that their terminology and process may be different. I would encourage you to speak with a lawyer in your state where you're planning to file for divorce. This webinar really does focus only on Texas. Okay, next slide. And so our agenda today, this webinar is going to focus on two big aspects of the divorce process. And these are things that people need to consider when they're starting to do a divorce. The first part will be related to children. There are lots of different parts involved with children. And then about halfway through, we'll go over to property division. some things you might want to consider related to property. So that's the main discussion points for today. Go ahead, next slide. We'll start with children. When I meet with a client, I always tell them that they should be thinking about three major topics. These are things you have to consider when it comes to your children. The first is going to be legal rights. And that means that when you're making decisions for the child regarding their education, medical needs, passports, all of those kinds of things are considered legal rights. The second thing to consider is called possession and access. I sign possession and access this way. And this really means visitation rights and what are the actual physical access to your children. The third is financial support. And a perfect example is usually child support. So we're going to talk about each one of these subjects in detail. Next slide, we'll start with legal rights. Next slide. And before I actually get into these legal rights, I want to go back and mention that often when I talk to my clients, people will say, I want full custody, just me by myself. But I want to let you know there's no such thing as full custody, really. The only way you can really have full custody, which means you have full 100% legal rights to make decisions for the children, where the other parent doesn't have that. That means, and it also means that you have the child with you all the time, and you think that, the other parent can't see them. People think that's what full custody means, but I have to let you know that there's no such thing as full custody. The other parent will always have the right to have some physical access to the child. So I need to clarify that right up front. The only way to really have full custody is if the other parent dies, or is if the other parent just happens to actually be terminated. If their rights are terminated, then that's a whole separate legal process. The other parent would have to kind of, do that and have their rights terminated. Then we would pretend that they didn't even really exist. They would be out of the picture completely. And so that's the only way you could ever actually have full custody. But more often than not, there is always going to be some kind of joint legal right and physical access to those children by both parents. First, we're going to talk about the legal rights again. And on the far left, you can see joint managing conservatorship. We call that JMC. And this is the most common thing that happens in divorce cases. That means that both parents have shared rights and duties to make decisions together regarding the children. An example of that may be tutoring. If this child needs tutoring for math, you would have to confer with the other parent. Would you agree that we're going to place our child into tutoring? You both say yes, and then you're able to place the child in tutoring. If the other parent says no, but I'm saying yes, then the result is usually no. If only one parent is agreeing and the other parent doesn't, then that means it cancels it out basically, so it's a no. When you actually talk to your attorney, it is very, very important that you communicate what your relationship with the other parent looks like. If the two of you are friendly and agreeable for a lot of the same things, you're basically on the same page, then and you're getting along, then JMC is, by agreement. It works well. But if there is continuous disagreement on lots of issues, the advice I always give to my clients is to add a provision called the tiebreaker. This provision in your divorce decree would mean that, say, you and the other parent could not agree on something. And let's use tutoring as an example I've already given you. I want it, they don't. And what's next is we would follow what the school recommends. A teacher or maybe 504 or ARD committee, if they are recommending that the child needs tutoring, then we would have to follow that written recommendation. However, if the ARD said they didn't need it, then we wouldn't follow, we wouldn't be able to have tutoring. So I recommend this anytime parents aren't agreeable, that you should always ask for a provision as a tiebreaker. Next is sole managing conservatorship. And this means that the parent has the sole or exclusive, is what we say, exclusive legal right to make decisions regarding the children. And if one parent is appointed as SMC, then the other parent becomes possessory. And so we call that PC and SMC. This really means that as SMC, I have the exclusive right to decide everything. I don't have to ask the other parent, hey, would you agree that we're going to put our daughter in tutoring? That's not necessary. I can make these decisions on my own. However, the other parent, as a possessory conservatorship, PC, still has a right to have access to the children. And that includes school records, medical records, information, conferences with the teacher asking how the children are doing in school. They still have that right. They just aren't able to make decisions for the children. And a lot of people are like, ooh, I want this. However, it's rare that you are granted a sole managing conservatorship. It's really only beneficial if there's been family violence or domestic violence, or if you have a protective order, a PO, against the other parent, then a sole managing conservator could be awarded. We have to have proof of that, though, if there's ever been any child abuse or neglect, or even CPS involvement. They've done an investigation and there has been reason to believe that abuse or neglect did happen. Then we can ask for a sole managing conservatorship or a possessory conservatorship. But I want to warn you, it is very rare that that happens. The Texas Family Code already has language that assumes that JMC should apply to all divorces with children involved, unless there's been things like family violence, child neglect, or child abuse. Then we can shift over to an SMC or a PC relationship. And so these are legal rights. Next slide, we're going to talk about possessory access. Okay, we've already talked about legal rights. Now we're moving on to physical rights to access the children. In Texas, we call this possession and access. Other states typically call this custody or visitation rights. But in Texas, of course, we always have to be different. We have our own terminology for everything. Now, when you look at this is just an example schedule. This is called Standard Possession Orders, and we call that SPO. And this is actually in the Texas Family Code that we are supposed to follow this schedule. And it's pretty much, by default, this is what's assigned One parent will have the primary custody, the other parent will follow a standard possession order or an SPO. And what it usually looks like is there's a calendar I've shown for this month. You can see that the first, third, and fifth weekends are where the other parent will take the children. It typically happens on Friday at 6 p.m. and lasts until Sunday at 6 p.m. Plus, every Thursday for dinner time, pretty much like 6 to 8 p.m. And so those are the normal standard possession orders. And as for the holidays, there's a long list that's included, but I'm just snipping out a few of these pieces so that you can see these as an example. On the child's birthday, if I am the one, that has my daughter that day, the other parent is allowed to come and pick the child up for dinner to celebrate their birthday from 6 to 8 p.m. Next would be something like Thanksgiving break. You alternate between the primary and the possessory based on even numbered years or odd numbered years. Christmas break alternates also. And I can give an example that if I had my daughter with me for Thanksgiving this year, 2024, that's an even number, then that would mean the other parent would have the daughter for Christmas. And then the next year, that would be switched. I would have my daughter for Christmas, and the other parent would have their child for Thanksgiving for the year 2025. Now, summers, the SPO will also have 30 days with their daughter or the child during the summer. So suppose that I have the primary and the other parent has SPO. That means they're going to have 30 days, but they do have to let me know by April which dates they want to have those 30 days. Maybe say from June 15th until July the 15th, that would be their 30-day request. They will be taking the child during that time for the summer. However, if there's been no notice by April 1st, then default says that July 1st to July 30th is the standard order. And of course, it would depend unless your orders had something different. But standard possession orders usually look like this. It's very common in our state here in Texas. Um, I also want you to know that we have another kind of standard possession order that becomes more and more, it's becoming more and more popular now called extended standard possession order or ESPO. And what this means is on the first, third, and fifth weekends, they're the same dates, but they add a little more time to extend the time with the other parent. So starting on Thursday after school, they would go with that parent and stay until Monday morning, where they would be dropped off at school. But everything else remains the same. It's just the first, third, and fifth weekends actually get a little more time, being from Thursday to Monday instead of Friday to Sunday. And it seems to be becoming more and more popular these days. And, as it does become more popular, it really makes it a 50-50 agreement. Next slide, please. And so this just shows an example of the 50-50. And what this really means is you're splitting your time with the children, literally 50% with you and 50% with the other parent. There are so many different kinds of schedules that this could work with in order to have the 50-50, but I'm going to show you two of the most common schedules to make this work. The first one is 1 week on, 1 week off. And basically that means that I have the kids with me for one full week, and then they go to the other parents for the next week. They stay there for that full 7 days, and then they come back to my house. So we alternate. And we only exchange the children once a week based on that. Typically, it happens on Sunday at 6 p.m. However, if you don't want to see the other parent and you don't want to deal with this exchange, you could use the school as the exchange. And an example of that would be that on my week when I'm done, I just drop the kids off at school on Monday morning, and then the other parent would be picking them up after school on Monday. And that's when his week begins. Of course, then it comes back to me. On Monday, I'd pick the kids up at school. And so there is a way to do that where you don't actually have to see each other and deal with each other. And that's one possibility that you could consider. The next slide. And this is just a second option that's pretty common where we're doing 50-50. And this is called the 2-2-5 schedule. And the reason why people like this is because a whole week away is really hard. A lot of people don't want to be away from their kids for a whole week. I wouldn't want to be away from my daughter. And some kids are too young. 5 is really, really young. They need to see their parents more often. So instead of the 1 week on and the 1 week off, they switch to this 2-2-5, where they get to see their kids more frequently. But it does mean you're going to exchange them more frequently too. So 2-2-5 actually looks like this, and this is just an example for you. The blue, let's pretend blue is my week, and the other parent's green. So on the blue days, that means every Monday and Tuesday, the kid is always with me, guaranteed. Mondays and Tuesdays are my day. And then Wednesdays and Thursdays are always guaranteed to be with the other parent. That's green. Now, we have to rotate the weekends. So if you'll see the first week there, you see on Monday, Tuesday, they're with me. Then they go with the other parent Wednesday, Thursday, but Friday, Saturday, Sunday, they'll stay. Then Monday, they come back to me because Mondays are always my day, and Tuesday too. But then Wednesday, Thursday, they'll see their parent, and then I will get Friday, Saturday, Sunday. And of course, I keep Monday, Tuesday, so you can see how it alternates back and forth. It's a 2-2-5 schedule. And it works pretty well, especially for younger children. You have to make sure that they have a close relationship with both parents. The week on and the week off usually works better for older kids. Those who are used to, going back and forth, and they may even have their own extracurricular activities after school and things like that. It gets confusing when they're switching too many times. So sometimes it is better for the child to spend 1 week at a time with each parent. It gives a little more stability. But you should know there are many, many different possibilities and visitation schedules that can be agreed on in the court order. I always, always try to add some language that says if you and the other parent can agree on a different schedule, that is fine. Do as you please. But if there's any disagreement or something happens where you're having an argument about a holiday, then you must revert back to the court order. So we do have to write, visitation as a standard in your order. It is required. But I still encourage parents to go ahead and make, decisions amongst yourselves if you can do so and be friendly. That works great for you. But there is always language that gets added about visitation and access into the orders. And it kind of serves as an insurance so that if something happens and you are now disagreeing, you have to revert back to the actual court order. Also, you can be very creative when it comes to this. I've had a few cases where it was very unique. I remember one pilot. He did not get his schedule until 1 month before it was time to work. And they changed his schedule often. And so they became very creative and said, hey, as soon as you get your schedule, you share it with the other parent and you agree for whatever 2 or 3 days you're available to take the children. And it was tricky, how we could make that work with his work schedule, but in other states and, cities that are if you live really far away from the parent, more than 100 miles, they have to come up with really creative schedules. So the best thing you can do is work with your lawyer and let them know. Some other advice I always give people that they should consider is often a parent is thinking about just right now. Your daughter's 5 and everything's okay right now. 223 is the best for my daughter right now. But I always want to remind people, hey, don't forget, what's this going to look like when the kid is older? Say 10 or 15 and s- so forth. It's like we want to make sure that you have a visitation schedule that's going to work well until the child is 18. So you have to look towards the future. It's not just about now. Keep that in mind of what could be happening between now and then. The goal is that you don't have to keep coming back to modify all of these things. We want you to be satisfied with your orders until the child turns 18. Next slide. On this slide, it was the holiday schedule. It was for the 50-50 basically. And it's really the same as the previous holiday schedule for the SPO. But the only difference that happens here is in the summer, both parents have 30 days. And normally, every year, they alternate and decide which dates the kids will be with which parent during the summer. So if I have them this year and I decide I want the kids from June 15th to July 15th, and the other parent decides whatever 30 days they want, typically the next year that parent gets to decide first and then I get the second choice. And so we take turns on the summer dates being decided. All right, next slide. Okay, geographic restrictions. This is one of my least favorite subjects to talk about with clients. Often the client who is like, "What? That's not fair. You're telling me I can't do something." But geographic restrictions are there and they're put, in place for the children. And there's different kinds of these restrictions. The most common one is the county that the children live in, plus surrounding counties. So anything around the current county, you can see the picture there on the left showing Travis County and then all the counties surrounding it. What this actually means is that from now until the child turns 18, you and the child can only move within Travis County, Williamson County, Bastrop, Hayes, Burnett, these surrounding counties. That's the only place that you're allowed to move to meet this geographic restriction. And that means no further away, no other cities, no other states, unless you and the other parent have agreed in writing. If there was, truly a new job in Houston and you needed to move, you're going to take the children with you. The other parent agrees to it, just get it in writing. That would be okay. Or you would have to go back to court and modify the orders and let them know, hey, judge, I've gotten a new job. I'm going to have to move. And you would have to see what the judge decides. Also, this geographic restriction, I know it's very, very difficult because, we grew up in a culture where I don't like people telling me what I can do and what I can't do. You're going to tell me I actually am stuck here for the rest of my child's life until they turn 18? That's not fair. People shouldn't be telling you what to do. I get that. I totally understand it, but I don't like people telling me what to do either. And I hate the idea of being limited. They're telling me I can only live in this area. However, the concept does make a lot of sense. The reason why they do this geographic restriction is because Texas, if you read the family code, this law really, really values and wants to make sure that children have a good relationship with both parents. It doesn't matter if the parents get along or not. The law doesn't care about that. They only care about the children, and it's in the best interest of them to have maintain close access and relationships with both parents. And so if one parent actually takes the children to another city or another state, it is going to severely impact the relationship with the child and other parent. And California's a long way away. That are we going to fly them a few times a year? Is it just going to be FaceTime? It's not the same as an in-person relationship when you see the other parent every other weekend and for the summer. So I do understand the concept. It does make sense. They want to make sure one parent doesn't just like, too bad for you. I'm out of here and take the child far away. The point is it's really in the best interest of the child. Also, if you really, really do need to move, then you could leave the children with the other parent. That's an option. It's a tough decision you might have to make. And so I know it's not the best, but we do have geographic restrictions placed on your orders. And there are two other common examples that are used. You can only pick one county possibly within, Travis County that could possibly be stated. You're not even allowed to move to surrounding counties. And normally that's popular for situations where you have the 50-50 because, at 50-50, that means that you're going to be exchanging the children. You need to be dropping them off and picking them up at the same school. And if you actually live in Williamson County, or say you lived in Travis County, but, someone else moves to Williamson County, that could become, quite a distance to travel. Or even, Travis County to Bastrop. That's easily an hour drive each way. So some parents are like, no, they prefer that we be limited to one county, and that's where you live, so that you're both there to make it easier to exchange the children and for school purposes also. There's another one that's even more restrictive, could be based on the school district. They call it a feeder school. And so if elementary, middle, and high school, they want to follow where, the feeder leads to the next school. So they want you to be within Austin AISD and able to attend those schools in the neighborhood. And so these are the three most common geographic restrictions that are placed in court orders. Next slide, please. Okay. If you remember, I talked about three different topics within these divorces. We already talked about legal rights to the children. We talked about possessory and access. Now the last one is financial support. And so this really means that child support is paid. And in the Texas Family Code, they do have guidelines on how they determine what child support should be. And here are the guidelines on this PowerPoint. For one child, the child support calculation is based on 20% of the monthly net income for the parent who has SPO. And so this really means that if I have the child with me and I'm primary for most of the time, the other parent only sees the child every other weekend. Remember the first, third, and fifth weekend visitation schedule plus Thursdays for dinner. That's the SPO. That means that they have to pay me child support for the children. And that means that the other parent will be paying 20% of their net income for child support. If you have 2 children, it goes up to 25%, 3 children is 30, 4 children becomes 35%, and 5 or more children, whether it be 6, 7, 8, 9, or 10, 40% is the max. That's the highest percentage that would be taken for child support. And now, how do you actually get this child support is the next question. The Office of the Attorney General, and we typically abbreviate that OAG. They do have a whole department that does nothing but child support. And they are the ones that will actually process child support. They will send out a form or they have an order which is called the Income Withholding for Support Order. This happens after the court is done and the orders are finalized. It goes over to the OAG's office and they will reach out to the parent's employer through their HR department. They will send this order to them and the employer will start the withholdings. It's then sent to the OAG's office. The OAG then processes it and will provide it to the other parent who is to receive this support. It's typically direct deposited to the parent's bank. This is typically how it works. Unfortunately, a lot of parents are like, no, I don't want the OAG to be involved. I prefer, I don't want my employer to know. I don't want, I prefer Cash App. Just have them send me the money or Venmo. I prefer that, $400 every month's good. I have to say no, sorry. The Texas Family Code law is very clear that you must pay this through the OAG. They must process it and then give it to the other parent. And it does make sense, of course. They want to make sure that you are guaranteed to receive these payments. And if child support is not paid or it's delayed, the OAG could then get involved and then file an enforcement order, which means that they could force the other parent to pay this child support. If we're accepting direct payments, it's very hard to prove that you haven't been paid. The OAG, of course, has a very clear way to track and report on payments. They know exactly how much has come in. They are able to categorize it into different needs. And so after a divorce is finalized, you will have to apply. I don't know if it's really apply, but you will create an account with the OAG. There's a website on the bottom that's listed there and a link for you to use. You can open that up and from there you create an account. You will put in your case number. You can upload a court order and you can also have your account information for your bank listed there so you'll start receiving those direct deposits. And I always encourage people, as soon as your divorce is finalized, please go in there, get the ball rolling, start this process so you can start receiving your payments. If you really want to know how much you should be paying, there's a nice child support calculator online. That's the second link here that I've listed there. This is really great. It will help you by just entering your information and you'll see what the other parent really is going to be entitled to, or you can see what you're supposed to be getting. One common misunderstanding that happens, I've seen a lot, is in the court order, it says something about the other parent has to pay me $300 on the first of every month. So on February 1st and then subsequent months after that. However, in reality, that's not how it really works. It kind of depends on how often the other parent is getting paid. Sometimes they only get paid once a month, or sometimes it's biweekly, and sometimes it could even be quarterly. So it really depends on how often they are getting paid. And people always contact me saying, "Hey, I haven't gotten my full amount. The money's not coming by the first." And I was like, "Oh, that's not how it works." The concept really is just for the total of this month. An example would be February currently. The total of $300 has to be paid. And occasionally, if the other parent gets paid bi-weekly, there are 52 weeks in a year, they will divide that by 26 weeks. And you might notice that your monthly payment is a little bit less. I would encourage you to use this calculator because it'll help you to understand better exactly what's going to happen based on your monthly pay, biweekly pay, or whatever that is. But it does really give you a real snapshot of what you're going to be receiving. And you may be receiving that twice a month or once a month, but it's really based on the other parent's pay schedule. Next slide. And so in the previous slide, we talked about just the charts and exactly how much money is supposed to be paid for child support. And this applies to situations where one parent has the primary custody of the children. They're the ones who are spending the most money. The other parent's only seeing the child every other weekend. And so it makes sense that you would be paying child support to relieve the financial burden that you have when the children are with you for most of the time. But hey, what would happen in a 50-50 deal where we're truly sharing? What would that look like? Because the other parent really is just sharing the financial burden equally as you are. And so this is where this comes in. It's called the child support offset. And the idea behind this is that if the two of us are truly splitting the children 50-50, we would then need to look at the income for both of us and calculate what child support should be. And so this determines how much we would be paying for the child, if I were the primary, but whoever has the higher income then would pay the other parent a portion. And we have to subtract. I know it's confusing to even try to explain this, but if I were earning $50,000 a year and my obligation would normally be 10,000 at 20% for one child, and that's a yearly total. The other parent only earns 30,000 and their obligation would be 6,000 for 20%. So what would happen in this situation is I earn more, which means I could pay more. We would take the 10,000 and subtract 6,000 and the offset becomes 4,000. And then we would divide that by 12 months and that would mean that $333 a month would be paid to the other parent by the parent who earns more money. So this is how a child support offset actually works. And you should know that often I do see this happen. Parents have 50-50 and they decide that they waive child support altogether. Nobody wants to do the offset. They just prefer not to even have it involved. And you could do that because as a 50-50, you get to make that decision. That's another option you may want to consider. Next slide. Other things that are part of financial support are health insurance. Normally, the parent who has to pay child support also has to provide health insurance coverage and pay those premiums every month. And that would include health insurance, dental insurance. But believe it or not, I need to let you know that the Texas Family Code does not say anything about vision insurance. And so often people are like, wait, I want him to pay for that. My child needs vision insurance. We can ask to see if the parent will agree, but by law, it is not required to be provided. It just really isn't part of the law. Luckily it's really cheap. It's like $5 to $7 a month, so it's usually not very expensive. But some people want to fight for it and they want to ask the other parent to pay it too. And they can do that, but I have to let you know that the family code only mentions health and dental insurance at this point. So once they're paying for this health insurance coverage, that's fine. But if there was a problem that should arise, and suppose I'm the primary, I have the full-time job, I have the kids most of the time with me, the other parent has the SPO, and he sees them every other weekend, first, third, and fifth, and doesn't have a job. Or maybe they're even self-employed. They don't have access to health insurance through an employer. Or, it's really, really expensive. It can be $500, $600 a month for the other parent to pay. We could instead say that as the primary, I'm going to provide the health insurance coverage, but the other parent's going to reimburse me for that. And that's just another option that could be considered. One parent pay the other parent the premium that I'm actually paying. And also, if both parents do not have access to private health insurance, there's none available, one of us could apply for Medicaid or CHIP, is usually what they call it, Children's Health Insurance Program, which would be interesting because the OAG actually does require one parent pay the cash medical support. And that means that you would have to reimburse the state for the Medicaid or CHIP insurance that the children are receiving if it's in the court order. But I just wanted to let you know about that. Next slide. And another part of this financial support for children is called unreimbursed medical expenses. Often parents will have to split these costs 50-50 for things that the health insurance doesn't cover. Usually, insurance will cover certain things, and there's some kind of a balance that has to be paid by you and not insurance. Here's just an example. I think that there was a balance left on this bill that you're going to have to pay the provider of $892.38. And this was, a medical bill for the kids. And this really means that I'm responsible to pay 50%, and the other parent is responsible to pay 50% too. Normally, one parent, would pay it off in full and then submit the confirmation of payment or invoice to the other parent saying, hey, you now owe me this additional $446. I see that become a problem sometimes, admittedly, and I've paid it, but you haven't paid me back. Come on. I'm actually seeing more and more people communicating with the doctor's office or the dentist and saying, hey, just want to let you know that this deadbeat dad has not been paying, and so I'm going to just pay my part to you directly. Please go after the other parent for their portion. It is happening more often. The dentists and providers are doing it, and that's okay. If you know you have to split it, they'll take a split payment as a provider, and it might make things easier for you. So it's just a possible option. I've seen it happen. Next slide, please. Okay, we have finished the first part of the agenda about children. I do want to mention one other thing that I want you to keep in mind regarding children. I often see, well, let me go back. Remember, I did talk about the legal rights, the physical rights of visitation and access, and then the financial support. Those three pieces were discussed. Often I see parents kind of mix these up. An example might be, hey, the other parent hasn't paid child support for 3 months. So I'm going to withhold the children. I'm not going to let them visit the kids until they pay me and catch up on the support. But I have to let you know this is not how it works. You still must allow the other parent access to the child and to visit. They have the legal and physical rights to see their kids. It doesn't matter if they're paying you child support or not. And I want to warn you, do not mix these three categories up. I understand that you can't, you want to use this against them, but you can't. Keep them all separate, okay? And so if they're not paying child support, then go ahead and tell the OAG or hire a private attorney to file for a motion to enforce to make them pay the child support. But you cannot withhold the children from the other parent because they are not paying you. I just want to make sure I emphasize this that you don't get to mix these up, okay? Now, I'm done with children. Let's move on to the second part of what I wanted to talk about today in the divorce process, and it's called property division. Next slide, please. Okay, so Texas really is a unique animal when it comes to property. And the reason why I say this is because Texas is one of 9 states, to the best of my knowledge, there's only 9 that recognize community property. That's community property, which means that once you become married and, all right, husband and wife, every dollar earned during the marriage, it doesn't matter who earned it, whether it was me or them, but every dollar earned, I'm entitled to 50% of. And so 50 cents on every dollar is mine, and the other parent gets 50 cents on every dollar earned as well. Also, every dollar spent is 50% mine and 50% theirs. And so that's called community property. Often when I talk to clients and I ask about property, what do you own? What does your husband own? Many times people will say, well, I bought a car while I was married. An example would be like, I just bought a car last year. And of course, it was during the marriage, but it's under my name only. It's not in his name, it's my car. But, I'm the only one making the payments. He's not paying anything. And I just kind of go, well, so doesn't matter. It really doesn't matter. It's community property still. It is not your car. He is still entitled to 50% of it, even though it's under just your name and you're the one making all the payments. He is still entitled to 50% of that. And so that's the definition of community property. And the idea of this is that, this is mine and this is his really doesn't apply. It's just a big, I don't know, it's not an accurate concept under the law. You really have to, disclose all the property that was acquired during the marriage, all the cars, houses, valuables, anything that you acquired after marriage. A big 70-inch TV would count. Technology, all your equipment and devices. It has to be listed all out because it's considered community property. And there's another kind of property called separate property. And with separate property, you can see that here on the other column. One says during marriage, that's community property. On the other side, that's before marriage. Separate property really means that anything you acquired before you actually got married is yours. If I bought a house before I was married to the other person, then that is my house. That is my separate property. It means after I divorce, I'm keeping the house. He is not entitled to 50% of it. Can't touch the house. I mean, there are other things that could be considered like your retirement accounts. If you built that up prior to marriage, then that's yours to keep. Now, you have to know that during the marriage, all of the interest and everything that was added to that account becomes community property, but not the full value of that retirement account. We would have to look at the date of marriage and right before that, how much the value of that account was. Suppose that, I had 100,000 in there, and then once I got married, it went up to 125,000. So it was a total, of 125, but it, only increased 25,000. So the other spouse would get 50% of 25,000. And the reason why is because I already had that 100,000 before I was married. They shouldn't be allowed to touch that. The 25,000 that was built up and acquired during the marriage is what becomes community property, and they are entitled to 50% of that 25,000, and that'd be about 12,500. The other 12,500 I would keep. Another way that this is considered separate property is as if something was a gift. If my dad gifted me $25,000 as a wedding gift, that would be considered my property. Or if someone gifted me a car, that would be mine. But of course, you have to have evidence to prove that. In the Texas Family Code, just by assumption, they assume that everything is community property. So, in order to rebut that, you would then have to prove your separate property by providing dates and records, things that you had prior to marriage, the title of the car, the property deed, all of those things could be submitted as proof that these things are separate property or were given as a gift. Other property that could be considered separate property would be an inheritance, something you received if your parents passed away, it was gifted to you, $500,000, that would be yours to keep. The spouse cannot touch that. And if you have any cherished family heirlooms that have been passed down, those are considered separate property because you had them before marriage. They're inherited. All right, next slide. This is a premarital agreement. Most people call these a prenup. In other states, they call it prenuptial. And of course, in Texas, we have to have our own terms. So we call it a premarital agreement, but really it's the same thing. Oh, excuse me. The purpose of a premarital agreement is to avoid community property. Remember, I already talked about my car, my house. I bought these things with my own money, and it's in my name, and I have to say too bad because that's community property. But if you have signed a premarital agreement prior to your marriage, then this will protect you. And really, the concept behind this is that everything stays separate property all the way throughout the marriage. You are able to maintain your own separate property. So every dollar I earn is mine, every dollar they earn is theirs. And it's not like, we're getting 50 cents on each dollar and splitting that up. That's not the case anymore. What's mine is mine, what's his is his. And I'm actually a big proponent of a premarital agreement. I wish more and more people would have this and consider it, but it just seems to be, an untapped market. A lot of people don't really want to do this. And I can understand there's some negative stigma attached to this, and people are like, "No, you shouldn't do that. When you fall in love with somebody, you never think about the possibility of a divorce. Oh, I really love him. I'm gonna stay married forever. We're never getting a divorce. Why do I need this premarital agreement?" However, I just want to put this out there to change your perspective a little on this. You know, when you get health insurance, people don't get health insurance because you think next year I'm going to have cancer. I'm just going to have this insurance ready. Or, next year I might go to the hospital for 2 months and be sick. So I'm just going to go ahead and get my health insurance ready. You just never know. You can't predict the future, but you still get health insurance, right? So the real theme is you just don't know. Health insurance is there to protect you. It's to make sure you have the financial means to cover anything if something should happen. And the same thing happens with your car insurance. You have car insurance because you need it. It's not because you know you're going to get in an accident. No. However, car insurance is there to protect you just in case something happens next year and you have an accident and your car is totaled. Ooh, lucky you have insurance to cover that, right? They're going to take care of helping you get a new car. So just consider this the same. It's a premarital agreement. Look at it as insurance. We call it marriage insurance. And so, of course, you're not going to think about getting a divorce in 5 years. However, if it were to happen, you would be very relieved to know that you have protected your assets and they have protected their assets. And it makes the property division so much easier. What's mine is mine, what's yours is yours, and it's easy and clear. So I'm encouraging you all to consider a premarital agreement if you have not done so. Next slide, please. All right. Okay. The biggest issue that's really common that I have to deal with is the house. What are we going to do with the house when it was bought during the marriage? It is community property. What's going to happen? I do have two common approaches of how we can handle this. The first one is to sell the house and split the proceeds. Whatever the profit is from the house gets split. And that means that the actual market value is considered. The house goes up for sale, and let's suppose it's just a $300,000 value. But you still have a mortgage, and you owe 175,000 on this house, so that will be subtracted, and whatever is left is considered your equity. That's going to be the profit made off the house. And that would mean that, you know, I'm entitled to 50% of the equity. The reason why is because it's community property. It doesn't matter who paid the mortgage or who paid the most for the house and who loves the house more. None of that matters. It's community property. So 50% is mine and 50% is theirs. And it would end up being 62,500 as mine, 62,500 is theirs. And there is an issue called a clean calculation. But I just want you to know, in reality, it's probably going to be lower because there are going to be some fees that had to be paid, closing costs, repairs, cleaning, all of those things and move out means that it's probably going to be a lot less than 62,000, possibly more like 50 each. But this was just an example I wanted to show how it actually works. And so this is just one possible way to sell the house. The other possible thing to do is next slide. Let's show. The second approach here is that you could actually take care of the house by having one spouse buy out the other, which would mean that the house value was 300,000. We're just using that as an example. And the mortgage is still 175,000. So there's 125,000 in equity. I would need to pay 50% of that to the other spouse if I want to keep the house. So in order to keep it and ask them to leave, it would mean that you would have to buy their equity out. I believe I forgot the number, whether it was 67,000 or whatever, but that's the amount you would need to pay them for them to get out of your face and leave. Or it could be the other way around. Suppose that they wanted to keep the house and I didn't want the house, which is okay. They would then have to pay me the 50% of my part of the equity before I left. And this is usually how it works. There are two very, very important legal documents that are required to make sure that this happens. And a good lawyer will just give you those documents, but this is something you may want to remind them of if you have to. Sometimes the lawyer just gets, moving right along, but you want two of these pieces of very important legal documentation before the divorce is final, or even at the final. Just make sure you get these two things, are called the special warranty deed. A special warranty deed means that it's the actual deed that you have to sign and have notarized. Your divorce lawyer usually drafts that. I've drafted lots of them myself. I have them ready to present. And then you will provide the current deed to the lawyer because we will take the language from your current deed and move it over to the special warranty deed. So that's very important to provide that copy to your lawyer. That will then be sent to the county property tax office, and we can file this for you too. If you don't know how to do it, we'll handle it for you. And the purpose of this special warranty deed is just to make sure that the title of the property is then transferred to your name. If your house is under both of your names, the court order of the divorce, and once it's final, does not take care of that. You actually have to file a special warranty deed with your county to make sure that the title of the property is transferred to one name only or to the spouse if they're buying you out. The second important legal documentation is the deed of trust to secure assumption. And what this is, it's pretty interesting. This applies to situations where suppose that the house has been decided that I'm going to keep it and I'm buying the other spouse out, but the mortgage is still there. And I don't want to refinance this mortgage because refinancing it means it's going to be more expensive and I can't really afford for them to increase it. If I want to keep the same mortgage, they have to know that we're going to file this deed of trust to secure assumption, which means that I've agreed to take over the mortgage in full. The balance is now just mine. And this is to secure a promissory note that you're going to pay this mortgage. If next year I decide I'm not going to make these payments anymore, the other spouse could take the house because the deed of trust to secure assumption is there. His name is still on the mortgage. It's going to affect his credit score. And so they would be able to take this house. But this is a good way that you can make sure that you have to make sure your ex-spouse is going to follow through and do what they said they're going to do. It's kind of like insurance. If they don't make the payments, then you can get the house from them. So this is a good way to make sure the other parent does actually keep up with the mortgage. Next slide, please. Now for vehicles, we would have to decide what's gonna happen with those, and vehicles are normally pretty easy to deal with. Usually the car that I've been driving to work and using to shop and see friends is mine, even though both of our names may be on it, or even if it's just in my name, it's still community property. What I typically see is the spouses agree that you keep this car, the other car I'm gonna keep, and we're done. However, you have to know that the debt on each one of these cars has to be assumed by the individual. If that's your car and your debt and you're gonna pay it, that should be under your name. And so this is a pretty common practice. However, there are some situations where it becomes very, bitter in the divorce, and they will fight for every penny, including the car. My debt for my car is higher than your debt for your car, so you need to pay some of my car payment too. And it's really, 50% of debt is supposed to be shared, so sometimes that could happen. But talk to your lawyer about that. If the other spouse is trying to do that, just get your lawyer involved. See how you can negotiate that out and handle that situation. Hopefully, but typically people don't care so much about the car. You keep the car you've been driving, I'll pay for it, kind of thing. There is one form that can be used. It's important to make sure that you complete this at the time of divorce, which is called the limited power of attorney. And this form is filed with the Texas DMV. It's their form. It's actually not a legal form that we've created. If you see this, it's here on the website. You can Google it and pop it up on the internet. Pretty easy to get a copy of this form. And that's, something you need to make sure you fill out with your ex spouse or whatever. Both of you need to sign it. And it just provides a process to be able to transfer the official title of the car to an individual name only. In case we were both on there, if it's his name and he's giving me that car, and this is the way you transfer title. It's very important that you fill it out and get it signed at the time or right before divorce is final. Okay, next slide. Oh, that's, this is really tough. When people ask me about what's the hardest part of divorce, it's not the children usually, and it's not the divorce, it's not the house, it's the pets. You know, I have seen a lot of fighting over pets. And, somebody wants to keep the dog, they don't want to share it with the other spouse. But often I always encourage these spouses to share custody of the pets too. The pet came with the children usually, meaning, the SPO, for example, the kids and the pets, are primarily with me all the time. The other parent sees, the child first, third, and fifth weekend, then fine. Go ahead and let the pet go with the children. All of them go visit the other parent for the first, third, and fifth weekend. That's just kind of how I encourage it. Or if you have a 50-50, let the pet go with the children every week. And that's normally what I try to advise the client. Of course, that's something you're going to have to think about too when it comes to pets. Often people forget completely about them. Oh no, the cat. And it should be added to the court order how you're going to deal with your pets. Okay, next slide. Okay, so remember when I had mentioned children and I was like, my least favorite subject to talk about was geographic restrictions. People don't like being told that they can't move. Now for property division, this is my next least favorite topic to discuss. Often they think that it's really easy to get spousal maintenance or support. Other states call it alimony, where you receive payments every month. However, in Texas, of course, we have a different word for this. We call this spousal maintenance. However, you should know it is not easy as people think to get this. Child support is very easy. It's standard. The judge really will make sure that both parents have the financial support to provide for the children because it is in their best interest. Child support is easy to deal with. Spousal maintenance is not that easy. It is very strict. There's a lot of elements that have to be met. And then we have a lot of case law that sets precedents about spousal maintenance. And that can make it much harder to receive spousal maintenance in some cases. However, I just want to let you know that I'm just going to explain the concept now and how spousal maintenance should be working. Here, you should see that first is that you have to look at, is the spouse who's asking for this maintenance, suppose it's me, I want it. Do I lack sufficient property to provide for my reasonable and minimal needs? That's the first thing to think about. I'm a lawyer, okay? I'm doing okay. I can pay my bills, okay? And me asking for spousal support is probably not going to look good. There's probably not a possibility of getting that. But if I was a housewife and a full-time mom and I only took care of the children, so I've never worked before, and I don't, have any education and just a high school diploma. I never went to college. I, would have to, it'd be hard for me to find a good job to pay for my 5 children and support them. Then that is a good example of a reasonable need. But then there's the next element. This next eligibility, you have to do this plus all these other things. So next is, was this marriage at least 10 years or longer? After that is, does the spouse have a disability, which would prevent me from working? An example might be that, I don't know, I'm trying to think of something, a good example. Maybe I have a chronic illness, heart failure, and I'm really struggling to walk across the room without breathing hard. I can't imagine having to go to work and do a physical job or even sit, for long periods of time, which may make me dizzy and I may be throwing up. I can't last more than 15 minutes on a computer. So you have to have a very serious case that's documented to back you up for medical treatment and needs, and records would all have to be submitted to the court for the opposing party to actually pay this. Or does the child have a disability, which would prevent you from going to work? I do remember there was a good example that I saw. A child was just a baby and had to have 24/7 care. Could not be left alone because they had some kind of a lung illness. I forgot what the exact term was, but they were on a feeding tube, had to be changed often, oxygen constantly, which needed to be monitored and changed as well. If they lost the oxygen, they would die immediately. So it was a very, very severe health need. And because of that, the mom couldn't work. They were there to take care of the son and daughter constantly. And so that would be another good example of getting spousal support or maintenance. And then they look at the big picture, like how long were you married? Did you have any employment history? Are you currently working? Health and physical and mental health and needs. What kind of access do you have to resources? Do you have any assets? So really, really, there's a lot that they really look at. It's very, very complicated. Not easy at all to receive this. They analyze every aspect of this, and you have to provide lots of documentation, including even a resume. So, there's strategies that can be used. Talk to your lawyer if you really need spousal maintenance. Then there's another issue with family violence. And I just want to clarify, he hit me once, or now that means I'm gonna get spousal support. No, you must have documented proof that he was arrested possibly and does have a criminal case or was convicted, and the family violence happened within the last 2 years of filing for divorce. It can't be something that happened 15 years ago. It must be recent. And really, each one of these things has extra elements that are expanded on. So I just want you to know it is not easy to get spousal maintenance. Of course, you can ask your lawyer about it, but I just want to make sure that you're realistic and know what to expect. There's no harm in asking. However, be prepared to have to come up with some other financial support that is not going to be spousal maintenance. All right, next slide. One of my rookie mistakes that I've made early on in my career when I started working as a lawyer was I would always forget to ask the client about changing their last name. That's one thing that I would just kind of move right through and forget about. And the client would be like, oh, hey, what about my last name? And I'd be like, oh, after the divorce, too late. But now I'm like, okay, I always keep it at the forefront. Hey, you want to change your last name or not? I ask. And part of my intake now at the beginning, I ask, would you like to change your last name? It's very clear, I always check it now. And yes, if you want to change your last name after the divorce, you have to know that it has to be your maiden last name that you had prior to the marriage. You cannot just come up with a new last name. You actually do have to go back to your maiden name. Second, communicate with your lawyer. Please let them know that they need to include that in the divorce orders. When you file in the county for your petition, it has to be stated. The language must be included. So as you proceed, you can then have it added to the court order as needed. But once the divorce is final and the judge signs off on this court order, you're done. It is not an automatic process after that. You are then going to have to actually go to all of these different agencies that I have listed here, pay some fees, fill out some forms, and show your court order that you're now divorced in order to prove that you can change your last name back to your maiden last name. So there are lots of different agencies and providers that you have to do that with. And I want to say thank you to my former legal assistant. Based on his experience, he got married, changed his last name, and then went to one of his appointments where he was really confused to see an interpreter that he did not want. And, the interpreting agency was aware of it, but the reason why they sent the interpreter was because the agency didn't realize that he had changed his last name. It was like, oh no. So I warn everybody, hey, when you do get married and your name changes, make sure that you update and communicate that to the interpreting agencies. Whether you're getting married or divorced, once your name is changed, let them know. Make sure that they understand who you are so that they are still able to look at your name with your preferred list of interpreters and, of course, those who you do not want to make sure that they aren't sent to you. Okay? All right, next slide. Okay. Wow. We are done. We talked about children, we talked about property division, and there are so many more things. This is just a tip of the iceberg, just a scratch of the surface. However, it's really important that you just have the foundational knowledge and you're able to ask your lawyer about more details during the divorce process. And you can talk to family and friends and get more information. Of course, this is just a foundation that I've prepared for you. Next slide. Okay. Thank you all so much. I am done presenting for today, but should you have any questions or concerns, please feel free to email me at the Zoom registration link where you got the confirmation. There's an email address included. You can email me questions or concerns or feedback. And, if you wish specifically something for a future webinar, please do provide me with that email because I'm hoping to do more of these in the future. Let us know what you would like to see, what topics are of interest. We would like you to share that with us and any feedback for this webinar, of course. Please follow us on social media because we do post blogs. We have YouTube videos there also. And there's lots of information that we're sharing. So please follow us on our channels and social media, and you will get lots more information about not just divorce, but enforcements, modifications, adoptions. There are just lots of issues that we put different blogs out for. So I hope you are looking forward to future training. Thank you so much for being here with us today. And I really do hope you learned something new. I know it was a lot, it may have been overwhelming, but don't forget, this is recorded. We're going to upload it to YouTube on our channel. Feel free to watch it anytime and review as needed. All right. Thank you so much. Have a good day, everyone. Bye bye. Thanks for being here.